Hi, this is Jen Rubin, and this is Jen Rubin's Green Room. Many of our concerns these days in politics are really about the law and about the Supreme Court specifically. Why is it doing what it is doing? Why isn't it doing certain things? Is the Supreme Court still acting like a court? Is the Supreme Court ready and ripe for reform? All of these questions swirl around so many different issues. And of course, the now begun trial of Donald J. Trump and the very basic question as to whether he can be prosecuted for crimes while in office. We're very, very lucky today to have with us Steve Vladeck, who is currently a professor at the University of Texas, will soon be at Georgetown Law. He is a renowned author. His book, Shadow Docket, is up for a ABA award, and it will be coming out in paperback on May 21st, so mark your calendars. It is a great book on a used-to-be obscure topic that is now extremely important. He also has a newsletter called One First, and it is a must-read for people who want to stay up on all things pertaining to the Supreme Court. So we're very fortunate to have him, and without further delay, I'll welcome him to the show. Steve?
Thanks, Jen. Thanks for having me.
Oh, it's my pleasure. It's finally nice to get a chance to chat at length with my favorite Supreme Court watcher and Shadow Docket watcher. Let's start with the Supreme Court's immunity case. This would be the appeal from Justice Chutkan's courtroom in which she held that, no, you don't have absolute immunity while you're president, and you can, in fact, be prosecuted. What surprised you initially about the case when Jack Smith asked for the Supreme Court, even before the D.C. Circuit took it up, to expedite and hear it right away? Did it surprise you that they said no? Did it make sense at that point to say no?
Is it possible that the answer to both questions is yes?
Absolutely. Please explain, Professor.
Well, so, in the sort of broad historical view of the court, it was an extraordinary request. The Supreme Court, at least historically, has been very reluctant to grant what's called certiorari before judgment, meaning basically leapfrogging over a federal court of appeals to directly review a federal district court. And the kinds of cases, Jen, historically, where they've done it have been, cases that basically define common law casebooks. The Steele seizure case, the Nazi saboteurs case, the Watergate tapes case, the Iranian hostage case. Once a decade. So by those standards, no, it doesn't shock me that the court didn't think that this particular dispute was of similar import. But lately, the court has not been so picky.
Yes.
Right. So since February of 2019, the court has granted cert before judgment 21 different times.
And what kinds of cases were those?
Not these. Some have been important, like the fight over President Biden's student loan debt forgiveness program, or some of the immigration cases coming out of the Biden administration, but some just haven't been. And so I guess I was surprised in the context of what the court has been doing lately, that it didn't do it here, all the more so, Jen, because I would have thought that staying out at that point would have made more sense if they were going to stay out altogether, if they were willing to let the D.C. Circuit have the last word. In retrospect, having had the D.C. Circuit issue this unanimous opinion from a very ideologically diverse panel, exactly the kind of opinion that might have well served as the last word, only to then have the court step in, is part of why I think it makes less sense in retrospect than it did to me at the time in December.
The obvious nefarious explanation, or maybe not so nefarious, is that they are trying to delay things. They are playing into Trump's hand, in which he seeks to push everything out beyond the election. Is there some less nefarious explanation for this?
Here we are. We've been talking for like 2 minutes, and you're already putting me in the position of defending the court.
Yes.
So, if they wanted to do that, they would have moved even more slowly. So it's worth stressing that when President Trump asked the court to step in, he only asked it to pause the January 6th trial further, pending his filing of a not yet filed cert petition, right? So he was basically asking the court just to pause things to give him time to file an appeal. Had the court acquiesced in that, that would have pushed the Supreme Court's role in this case to next fall. And so I think it is, at least a one cheer for the Supreme Court for treating his stay application as an appeal, granting the appeal, expediting it, albeit not as much as they could have and not as much as they have in the past, to ensure that they would resolve the case at worst, right, by July 4th. That's not fast enough to appease anyone, I think, who wanted to see this issue resolved, but it is faster than the court would normally have moved. And I think the question is, does the court get basically a participation trophy for this somewhat in the middle timing decision?
So normally you would expect the court that got either a stay request or a cert petition, they might have held it over till October, for example. So even though we're hearing it 5 or 6 weeks, I believe, after the initial stay request, that's fast by Supreme Court standards, correct?
It is, and I think it is fast by the standards of 99.7 or 99.8% of the cases the Supreme Court hears. Jen, the problem again, I talk a lot in my newsletter and in my other writings about the Supreme Court about how sometimes the court is its own worst enemy.
Right.
And I think this is another example where the court's own recent behavior is the real problem because the court has moved even faster. For example, in the Colorado disqualification case.
Yes.
For example, in the Texas abortion case back in the fall of 2021. Folks have cited Bush versus Gore as an example of the court moving faster. I'm not sure we really want to hold that out as a positive example of anything.
Right.
So, yes, this is the court moving much faster than it wants to. I think it's still unsatisfying to a lot of people because it's the court not moving as fast as in recent years it has shown itself capable of moving.
Now, you said at the latest we would get the opinion, assuming that the court lets out at the end of June, although these days they've been kind of trickling into July, by the way, that we would get our answer at least then. But they didn't take that long to render the decision in the disqualification in the 14th Amendment case. And many of these other cases, they have decided more quickly. Would there be a objective rationale for why they couldn't decide quicker? In other words, correct me if I'm wrong, but the Watergate case, they issued an opinion within weeks, not months.
16 days.
16 days. So if they really wanted to, couldn't they act sooner than the end of June? Or does that suppose that there would be unanimity?
So I think that's the key, right? That the Watergate case, two things were true about that. The first is the court was not just unanimous, Jen, it was resolved from the get-go to be unanimous. And so what took 16 days was actually simply figuring out what all 8 of the participating justices were willing to agree to, right? The other thing about the Watergate case is that was argued and decided in July of 1974 at a time when the court had only one other case before it, the Detroit school desegregation case. Now we're talking about the court, tacking on the Trump immunity issue to a momentous, crazy, chaotic term in which they're very far behind on decisions, even in cases that were argued back in October. So, could the court move as fast as it did in Nixon? Could we get a decision, say, by Memorial Day? Absolutely. If the court's unanimous, if there's a dissent, or a bunch of separate concurrences, those tend to take time. And so I think it's really a question of, how united a front is the court in a position to present? That's going to drive the timing, Jen, to me as much as anything.
Now, before we get to the merits of this, I want to ask you about Clarence Thomas sitting on the case at all. This would not be the first case that he sat on involving the, I'll use in quotations, insurrection. And yet we know his wife had direct communications with the White House on this very issue, and there were texts that were relevant to the story, if you will, the entire issue. What should be the standard for Clarence Thomas's participation in these cases?
Well, I mean, what should the standard be and what is the standard are, as
Yes.
you know, two very different questions. I would prefer a world in which there was a clear standard that, in this case, required Justice Thomas to recuse, because I think there is just so much visible public interest in, concern about, right? Not just the fact that his wife was involved, but the sort of the assumption that he was aware of her involvement. I mean, the commentary tends to sort of focus on Ginny at the expense of Clarence, right? But the
Yes.
notion that he's oblivious to all of this, I think, is the real problem. That said, I mean, I am a bit of a formalist when it comes to at least our existing recusal standards, and I think there's a big difference under our current rules between cases in which a judge or justice ought to recuse and cases in which they must. And I don't see the argument that the immunity case for President Trump is a must, because nothing about the 4 charges against former President Trump or the question of whether he's immune from any or all of them turns in any way on anything that Ginny Thomas did. In contrast to, a case from a couple years ago called Trump versus Thompson, where President Trump tried to prevent the National Archives and Records Administration from turning over a bunch of materials to the January 6th committee that, so far as we know, may have included text messages between Ginny Thomas and Mark Meadows. That, I think, was a much, much more obvious case where, even under the existing standards, weak though they may be, Thomas had to recuse. And not only did he not recuse, he was the one public dissenter from the Supreme Court's order clearing the way for those documents to be turned over. So, I think the Thomas recusal conversation has multiple levels to it. I don't think he has to recuse in any case remotely touching on January 6th, but I think he's already shown that he's not recusing in the even minority of these cases in which I think he has to.
But of course, the Supreme Court says, oh, we have a ethics rubric now, and we will enforce it. But of course, there is no enforcement mechanism aside from the court in the way that Chief Justice Roberts of the court has agreed to. So there is no higher authority to go to.
There's not. I mean, I think, I've written about how Congress could create an Article III Inspector General. The constitutional line here is tricky. It would not, in my view, be constitutional for Congress to give anyone direct control over the justices' decisions. I mean, the whole point of having a Supreme Court is that there's no super Supreme Court.
Right.
But, Jen, I mean, sometimes you don't need... sometimes just the specter of transparency, right, will do enough. And so one of the things I've suggested with regard to an Article III Inspector General is that the Article III Inspector General would regularly file reports about the justices' financial disclosures, about their compliance with the relevant recusal standards, where maybe all the Inspector General does is say, here's an example where Justice X did not, in my view, comply with the recusal standards. That wouldn't provide any immediate penalty, but I think the public shaming of it, right, would exert downward pressure on the justices to behave better. And if you really, Jen, had a case of a justice who was regularly not recusing when they were supposed to, then you have the Article III Inspector General's work providing the factual basis for an impeachment investigation in the House. There's this specter out there that, because the Constitution limits everything Congress can do, because Congress can't do whatever it wants to the court, Congress can't do anything to the court. But that's not the same thing. And I think that's where the conversation really ought to move.
Right. Let's go back then to the merits of the immunity case. The D.C. Circuit was quite emphatic and quite unanimous, as you point out, and saying, no, there cannot be absolute immunity. And they used the famous Seal 6 example, that we can't allow presidents to order Seal 6 to assassinate their opponents and get away with it. Or an even touchier example would be to go assassinate senators who are voting on their own impeachment. So that seems to be completely out of bounds. But the court really didn't address an issue, which I think this Supreme Court case is going to have to. And that is, do we really want to be able to bring criminal actions? I'll use the example of LBJ. He lied to the country and made up the Gulf of Tonkin, the argument would go, and therefore is guilty of murder or war crimes or some other statutory infraction. Doesn't seem like we really want to do that. So how do you differentiate between having criminal trials over not just Gulf of Tonkin, but immigration laws, economic decisions, and what we have here, which was an attempt to prevent the peaceful transfer of power?
Right. Or imagine a president who says to his Secretary of Commerce, I want you to go lie to Congress. Isn't that conspiracy to obstruct an official proceeding?
Yeah.
Right. It's the right question. It is absolutely the question that at least the middle of the court is going to be focused on. And I think it's hard. I mean, I think, there are two possible ways to do it. One is to have robust checks on rogue prosecutors in those cases, basically sort of really provide for aggressive pretrial review of whether the charges are serious. And if so, them's the breaks. Jen, the other is to either have or at least assume without deciding that there is some small official act type immunity where, if the president is doing things that are directly related to his constitutional functions as president, either he can't be prosecuted or there's a higher burden for the prosecution. I guess what I would prefer is for the Supreme Court to just save that for the future hypothetical in which it arises. I mean, there's a reason why in 234 years this question has never come up before. We haven't had a rich history of presidents committing crimes, at least committing easily verifiable, triable crimes. And I guess, it seems to me it shouldn't be hard for the Supreme Court to write an opinion that says whether or not there is a core of constitutionally protected action a president might take. The charges here fall so far outside of it that we don't have to work, that we can save that for another day. Right. That would be, I think, the way to build consensus among this court if they wanted to do it.
And that was essentially Jack Smith's argument, wasn't it, in the papers that he filed?
Yes. I mean, he says at one point, and worst case scenario, articulate a standard and send it back to the district court and we'll win.
Yes.
Right. So if there's a test, fine, we'll go satisfy it before Judge Chutkan. The only real case we have here is on the civil side. It's Nixon versus Fitzgerald from 1982, where the court, only by a 5-4 vote, articulated this idea that the president should be immune from civil liability for conduct within, quote, the outer perimeter, unquote, of his official duties as president. And, I have sort of qualms about applying the outer perimeter standard to criminal liability too. So did the court. I mean, we now know from the justices' papers that the majority in Nixon versus Fitzgerald assumed that there was criminal liability in that case.
Right.
But I guess even that standard presumably would put Trump's culpability for January 6th on the prosecutable side of the line. And Jen, we can save the hard hypotheticals for for the future where we have to deal with them, as opposed to letting that get in the way of the obvious criminality here.
Now, let me be nefarious again for a moment. You can't be cynical enough, as I say about the Supreme Court. Let's say, in the vein of making things more complicated, the justices decide that there is a 5-point test with 3 sub-points for determining whether there is immunity. And they send it down to Chutkan, who applies this test. And then, of course, Trump's lawyers say, well, you didn't apply this very complicated, very unclear, very obtuse, very vague test properly. So up we go again to the Court of Appeals and the Supreme Court. What's the likelihood of that? And does the Supreme Court really want to do that?
I mean, the likelihood that Trump does that is, whatever, if there's a number bigger than 100%,
Yes.
right? It's like when my daughter's pediatrician told us when she was 3 months old that she was in the 104th percentile for height.
Yes.
If we had to explain to her there was no such thing. So he'll certainly try it. I do think that it could move pretty quickly. I mean, right, because he would need also, again, a stay of the trial. And I think, in a world in which Judge Chutkan faithfully applied whatever test the Supreme Court articulates, the D.C. Circuit would quickly deny a stay. I think the Supreme Court would fairly quickly deny a stay as well. So I suspect that the justices won't be that worried about this particular problem in structuring their decision, but it really does get back to the broader question of whether there's really consensus going into the argument in this case that the court wants to speak with one voice. There's a real distinction in the sort of the meta-political decisions the court has handed down historically between those in which the court was able to achieve unanimity and those in which it wasn't. We talked about the Watergate tapes case and the importance of having a single opinion written ostensibly by Chief Justice Burger. Contrast that with Bush versus Gore, where the divisions were a huge problem. Jen, contrast that this term with the Colorado disqualification case, where the separate opinion by the 3 Democratic appointees, I think, really called into question some of what the majority opinion did. So much of this just depends on something we won't know until we know, which is, is the court of one mind about this, or is there going to be a sticking point between some number of the Republican appointed justices and the rest of the court?
Jack Smith has to get to 5.
Yes.
And where do you think the balance would lie? And what do you think is the best argument for him to get those 5, or maybe get more, in the sense that perhaps the Supreme Court doesn't care about it, but Jack Smith might care about the appearance that this is a legal issue, not a political issue. Daring position, I know, but he might want the consensus to be other than the usual, I guess now 3-6 division, but even beyond a mere 5. How does he get to 5 or beyond, and what's his best way of doing it?
That's what makes this case so interesting, right? What he really wants is 9.
Yes.
The best possible thing for the country. Well, the best thing for the country is probably 8 with Thomas recused. But right, but a unanimous short opinion from the court that comes out in 3 to 4 weeks, I think, would be the best possible case scenario. Short of that, I think, if I'm Michael Rubin, who will be arguing on behalf of Jack Smith, who's about as veteran a Supreme Court advocate as exists today, I'm thinking about 6. And I'm thinking about the obvious 6. I'm thinking about the 3 Democratic appointees, the Chief Justice, and Justices Kavanaugh and Barrett. And I would love to get the other 3, but if I get those 6, I'm where I want to be. And Jen, I'm fairly optimistic that those 6 justices are at least of the view that former President Trump can stand trial for at least some, if not all, of his conduct relating to the January 6th insurrection. Again, the question is, how do they write that opinion? Is there a way to write that opinion that attracts some of the other 3 justices? And is there a way to do it that moves fast enough, for this trial to actually proceed later this year?
I've made the argument, and I'm glad you included Justice Barrett in there, that there certainly are cases in which all 6 of the so-called conservatives absolutely line up together. And we've seen that in abortion, we've seen that on guns, we've seen that on some other cases. But we've also seen that Justice Barrett in particular has been flexing her muscles just a little bit. Even in the 14th Amendment case, the disqualification case, she chose to write, all of these were concurrences, but she chose to write separately rather than either join the 3 or join the others. We've also seen her show a little deftness in one of the immigration cases coming out of your circuit, the Fifth Circuit, in kind of goading the Fifth Circuit to act so that they didn't, it's a little obtuse, but so the Supreme Court didn't have to muck around in some sort of administrative procedural issues at the Supreme Court. What is your view of Justice Barrett, and do you see some greater institutional inclination than you might see from a Justice Alito or a Justice Thomas?
You totally stolen my thunder. So
Oh, no.
there's an op-ed that I have sort of almost ready to go, but I'm waiting for the right sort of hook, which is basically called "This is Justice Barrett's Court." And the premise is exactly what you say, that if you line the justices up ideologically, on the assumption that the fourth vote on the left side of the center is Chief Justice Roberts, which at least in the bigger institutional cases, I think is probably a relatively safe assumption. Jen, I think it's increasingly clear that the more likely, not always, but the more likely fifth vote in the typical case is going to be Barrett, not Kavanaugh.
And why is that?
I think it's for two reasons. So one is just they are very different insofar as their backgrounds. Right, Justice Kavanaugh came up through the executive branch. He was President Bush's staff secretary. He was, Ken Starr's associate independent counsel. I mean, he was, a lawyer in the midst of the partisan political thicket, as much as I think one can be. And so I think his judicial philosophy is very, very shaped by partisan politics. And as a result, I think, is a little more susceptible, right, to the politics of the moment. Whereas Justice Barrett's a law professor, and she's a law professor who has, very right-leaning views, but views that were formed in the crucible of the academy, where I think they have, less sort of transitory attachment to contemporary political agendas. And so, on the big social issues, that doesn't mean she's moderate. She's, we know where she is on abortion, on guns, on religion, on all that stuff. But on institutional stuff, I mean, I think when it really matters for rule of law purposes, I think she's, I hope both Justice Barrett and Justice Kavanaugh are reliable votes for the rule of law, but I think she's even more reliable for that. And I think the examples you mentioned, her concurrence in the disqualification case, her fifth vote in the razor wire case back in January, which did not get a lot of attention. I think we're going to see more examples of that later this term from Justice Barrett. And so, I was struck, for example, in the oral arguments in Fisher, in the January 6th obstruction case, that she was perhaps the Republican appointee who was the most skeptical of the petitioners.
Yes.
So, it's not going to be in every case. There are going to be counterexamples. It's not as obvious as when it was Kennedy with 2 blocks to his left and his right.
Yes.
But I think more than Kavanaugh, she is the middle of the court now in the cases in which it's going to matter the most.
And you can hear your progressive friends pulling their hair at the notion that Justice Barrett is the center of the court. We've come from Justice O'Connor to Justice Kennedy to Justice Barrett. But
I will say, I mean, I what little hair I have left, I think is also, potentially at risk. But, am I would I prefer a world in which Justice Barrett is the median voter on the Supreme Court? No. Am I fearful for the rule of law in that world? Maybe less so than a lot of my friends on the left.
So let's take a different example, which was the mifepristone case.
Yeah.
This was the case in which the group of doctors who query whether they ever had patients that used it, basically brought a case saying, we don't want to be confronted by a case in which someone wants this medication or we have to recommend it. Therefore, please take it, if not out of circulation, roll back the rules to make it more difficult to obtain. And the government and other groups were saying, wait a second, you can't bring a case in federal court on the notion that you're bothered by what other people are doing, or there might be a situation in which you might be confronted with some kind of conflict. And the fancy pants legal term for that is standing. Was Justice Barrett more skeptical than you would otherwise imagine in that oral argument on that issue of standing? That's kind of a rule of law issue as well, because it used to be conservatives, said you have to have strict standing. Otherwise, you have the court mucking around in all kinds of issues and essentially handing down advisory opinions.
So, I mean, she was very skeptical of the plaintiff's standing in the mifepristone argument. Jen, in some respect, that's no surprise. The mifepristone case, we already have two really strong clues about where the court is in that case. The first is the fact that last April, the court voted to freeze Judge Kaczmarek's order for the whole duration of this appeal, and the only public dissenters were Justices Thomas and Alito. I think it's not a stretch to think that Barrett was in the majority on that order, even though we don't know for sure. Another really weird procedural thing that happened, the court denied the cross petition, which the plaintiffs had brought, where they had asked the court, in addition to taking up the government's petition and the mifepristone sponsors petition, to also take up their challenge to the issue they had lost on in the Fifth Circuit. That's a very, very weird procedural move unless the court wasn't inclined to get to those merits, right? Which is another sign that the court was going to say no standing. I don't know that Justice Barrett is a stickler for Article 3 standing the way that, for example, Justice Scalia used to be. Justice Barrett was in the majority last term in the student loan case, where I think the court really messed up Article 3 standing doctrine in holding that Missouri could challenge the Biden administration's student loan debt forgiveness program. And Jen, that was after she had been skeptical at oral argument. So it's possible that, we don't know where she is based on the oral argument. That said, I think by the time this term is over, if we cannot be sort of totally captured by Trump cases, even though I understand why we are, there's going to be a fair number of decisions where a majority of the court that will sometimes include Barrett and sometimes Kavanaugh and sometimes both is going to be pushing back sharply against the Fifth Circuit in particular on standing, on some of the constitutional things the Fifth Circuit has been doing with regard to administrative law, maybe even on immigration. And so, I don't know that Justice Barrett's going to be leading that charge, but I think that when you see it, it's going to have the usual suspects where the sort of the middle three justices, middle not because they're moderate, but because in any set of 9, there's a middle 3, right, I think are going to have a lot to say about the Fifth Circuit that is going to be more consistent in the short term with what the Democratic appointees believe than what the other 3 Republicans do.
Let me get back for a moment to the 14th Amendment case. The justices didn't simply decide that the states shouldn't be making this call. In other words, you don't want the Arizona Supreme Court going one way, the Utah Supreme Court going another. That's really all they had to decide. They could have gotten that far and then said, okay, because of that, we're now done. This was a decision by the Arizona Supreme Court. Fine, we're not going to let states do this. We're done. But they went further. They gave, and there's some dispute about what it is exactly they said, but they went even further and said, oh, and by the way, you can't do anything in this area until Congress acts. Why do you think they did that? And what is it that you think they really did? Because there's some confusion about what would constitute Congress acting.
Yeah, I think part of why the majority did what it did is it's worried not just about states misbehaving, but it's worried about individual federal judges misbehaving. And so, it's one thing to say states can't act. And I think that would have adopted and attracted the support of all 4 of the other justices. But by saying the only way to do this is through congressional enforcement, you're taking the sort of federal courts off the hook. So, for example, if somehow former President Trump wins re-election, I can't walk into federal court on January 21st next year and challenge an official action he takes on the ground that he had no authority to take it. Right? I think that's a big part of what they were worried about. And so, the idea of sort of limiting this to Congress specifically, I think really is about saying we don't, we want to take out all the outliers. What I find bizarre about that is sort of 2 things. One, it also discounts one of the ways Congress might enforce Section 3, which is by refusing to count electoral votes. in favor of someone who a majority of both chambers, because it would have to be both chambers, right, believes committed insurrection. And two, it also goes past the president to include anyone running for federal office, members of the House or the Senate, even though, Jen, historically, those have been viewed as statewide offices where states have had more control. And so I guess, I could have lived with a world in which the majority said it has to be federal, not state, if it were only about the presidency, right? And if it left room for Congress to act in any way that the Constitution authorizes Congress to act, to limit Congress to simply passing a statute, which, let's be clear, requires the president to sign it.
Yes.
Or a veto-proof supermajority of both chambers to override a veto, is one in which Section 3 is going to be awfully darn hard to enforce, even in cases in which we all think it is, absolutely clear that it ought to be.
So just to carry that through on what an upside-down world we're in, the very people who brought objections to the electoral slate in 2020 would, if Trump were the winner on election night or thereafter of the Electoral College, say, nobody can object here, and refuse to count the electoral votes for President Biden, even though he may be an insurrectionist, because we haven't passed a statute that says, oh, by the way, whether it would be specific to him or not, but this is insurrection and you can't be president. They would be arguing exactly the opposite of what they argued in 2020.
And I think that in that respect, again, I think the decision in the Colorado case reflects a remarkable naivete on the Supreme Court's part, because either the justices don't think that this scenario is possible, or they're just hoping that someone's going to take them off the hook.
Right.
That the American people are going to take them off the hook by not voting for former President Trump. That worst case scenario, Congress will be divided. That Republicans will control at least one chamber of Congress in the next Congress, which would prevent the kind of unified objection to electors that you would need under the Electoral Count Act of 1887. But, that's quite a risk for the Supreme Court to take.
Yes.
And it's why I really wish that they had just sort of stuck to the narrower proposition that clearly commanded all 9 justices. In a way where the majority opinion ultimately and unfortunately didn't.
Right. It was also interesting that the so-called 3 liberals didn't file a dissent. It was a concurrence, which left me scratching my head how you could be a concurrence and yet specifically disagree with one basis for the opinion. Explain that one to us, if you could.
So, this is a bit of a sort of formality, but I think it's an important one, right? So when justices say that they are concurring or dissenting, right, they're talking about one of two things. They're talking about either concurring in or dissenting from the rationale offered by the majority or simply the judgment. And the judgment in the Colorado case was to reverse the Colorado Supreme Court on the ground that the Colorado state courts could not of themselves disqualify former President Trump. And Jen, the 3 Democratic appointees agreed with that.
Right.
And so they were clearly concurring in the judgment. They were nevertheless disagreeing in fairly strong terms, right, with the reasoning, much like Chief Justice Roberts in Dobbs, who concurred in the judgment even though he vehemently disagreed with the majority's decision to overrule Roe. I think historically, there are examples of justices calling opinions in those contexts dissents to sort of amplify that they're disagreeing, even though I think concurrence in the judgment is more technically correct. But also, as you know, right, the metadata sleuths discovered that actually the first PDF that the Supreme Court posted to the internet had metadata reflecting that the opinion was originally a dissent by Justice Sotomayor.
Exactly.
So I wonder if there was a deal where, in exchange for the majority doing something different, Sotomayor agreed to change her opinion from a dissent to a concurrence, or maybe to get Kagan and Jackson to join it. But the terminology, I think, ought not to drown out the sort of the oomph, which is, why are we going further? And indeed, in going further, what are we doing? We're getting this wrong.
Now, there's some optimists out there who say there's an even bigger deal in the works here, that the Supreme Court kind of took not only off the table, but really out of the kitchen, out of the dining room, any 14th Amendment issue. But they're now prepared to deal with this immunity issue in a relatively unified fashion in order to make sure that Trump faces the music in criminal court. Do you think the justices think that way? Do you think that may just be a practical outcome? Or do you think that's part of the way they kind of manage the court's business?
I think they're all different. I think some of the justices absolutely do think that way. I think Chief Justice Roberts wakes up in the morning and goes to bed at night thinking that way.
Yep.
I think to a degree, Justice Kagan thinks that way. And so at least for some of them, I suspect that there is a fair amount of interest in, if not pressure to, offer something of a mixed verdict on the Trump cases. And we know for a fact that the court thinks about this in other contexts, that the court has thought about sort of when it hands down decisions, holding cases over to avoid how they're viewed, et cetera. What that means on the ground, though, is just so hard to say because we don't know what the baseline is from which you're making a compromise.
Right.
Right. And so, if the daylight between the justices going in is very modest, that's one thing. If it's very, very big, if there are at least 2 or 3 justices who really think that former presidents ought to be immune in the circumstances of January 6th, that's going to, I think, make it really, really hard, right, for the court to forge the kind of institutional compromise we've seen in the past. And I think that's unfortunate. I mean, I think the reality of the court historically is that it has often been at its best when it has handed down decisions that were not necessarily the most legally persuasive things anyone's ever read, but were the court speaking with one voice on a question of national importance. And I worry about this court's inability to do so in a case as, quote unquote, easy as the Colorado case, and what that portends for the immunity case, which might be in some respects harder.
The irony, of course, or the tragedy, is that Chief Justice Roberts thinks of himself as an institutionalist. And the way he talks in public and often the way he offers opinions, that he is looking out for the longer-term issue of the court's credibility. We now have a situation where the credibility of the court has never been lower. Is it something that he has done? Is it something that Congress has done? Why has he lost the ability to keep the Supreme Court, in very general terms, in step with the American people, for lack of a better term?
There's a lot to that question. I dare say there might even be a whole book to write in response to that question.
Sounds like it's calling your name.
We'll see. So, I think Chief Justice Roberts bears some of the responsibility, but not all of it. But that's true of everyone in the story. So, Jen, I think there really is a story to tell about Congress's relationship with the Supreme Court and how it has completely changed over the last 35 years. If you just look at the Supreme Court from the founding through the 1980s, the court is regularly in dialogue with the political branches, right? The court is asking Congress for stuff on the regular. It is, sort of talking to Congress in its opinions. The justices are going to testify in support of court reforms, right? Congress is pushing back. Congress is giving. Congress is taking. Congress is using the court's budget as a cudgel. Congress is using the justices' pensions as cudgels. I mean, there are episodes of this all throughout American history into the 1980s. And then right around the time that Congress gives the court just about complete control over its docket in 1988, this all stops. And Congress basically leaves the court alone, maybe because it was, the court of the 1980s was a middling, moderate institution that Congress was not that worried about. And the problem is that has, I think, obscured how important it was for the justices to be always looking over their shoulder. So today we have a court that doesn't look over its shoulder at all. I mean, last summer, Chief Justice Alito gave this remarkable quote to the Wall Street Journal denying that Congress has the power to regulate the court in the first place. I think Chief Justice Roberts could have done more to arrest that slide. But he's only one man, right? And, he doesn't have that much formal power over his colleagues. His real power is the power of persuasion and to lead by example. And I think, part of this trend of the court disengaging from Congress as Congress is disengaged from the court is one he amplified when, starting in his year-end report in 2009, he stopped asking Congress for anything. A very subtle but I think significant development in the dialogue. With the leak investigation, he said, no, absolutely not. I will not have the FBI come into the court to figure out who's responsible. We are an insular institution. So yes, the chief, I think, is a figure in the story, but this all started before he was ever on the court.
Right.
And it would have taken, I think, a real effort, not just from him, but from a bunch of his colleagues, to really sort of continue to hide the symptoms of the disease. And what has happened instead is, with the departure of Justice Kennedy in 2018, there's no longer anyone on the court who is pushing the competing blocs to moderate their behavior. Right? It's now transactional all the way down. And that means that the last speed brake is off. And that's why we see, since 2018 specifically, so many examples of behavior that used to be just something we would never think of from the court because it was worried about the consequences. There are no consequences today, and that's the problem.
I would highlight one thing that Chief Justice Roberts did that I thought was symptomatic of what you're talking about and outrageous, was his refusal to testify before Congress on an ethics regime. There was nothing improper about that. There was no reason that he should have considered himself immune. There might have been questions that he would decline to answer about who recused in what case. But what was the basis, other than arrogance, for saying, I'm not going to show up and testify?
Well, I mean, his letter to Senator Durbin said, right, the sort of the separation of powers and the risk of overriding judicial independence.
Yeah.
And the reality is that historically, justices, including chief justices, have testified a lot when it was about what the court wanted or needed, as opposed to when it was about things the court didn't like. There's a remarkable House hearing about the Supreme Court's budget in early 2001, that basically turned into a referendum on Bush versus Gore.
Wow.
With Justice Kennedy sitting at the witness stand.
Wow.
And there's some remarkable video footage, right, of Kennedy defending Bush versus Gore to the House Judiciary Committee. So it's such, Jen, a powerful symptom of the broader problem, which is not that we have 6 conservative justices. It's not that we have a court that is less beholden to precedent. I mean, we've had that before, right? What's unique about this moment from the Supreme Court's perspective is how unaccountable the court has become. And I think a lot of the individual symptoms folks might identify on a day-to-day basis actually trace back to this much deeper disease in which a whole lot of people are responsible and culpable.
That is fascinating. And I must say, a unique perspective that we don't often hear. This is a very big question, and we only have about 5 minutes left, so do your best. Clearly, there's something wrong at the court. People have all kinds of ideas for reform. President Biden set up a commission on Supreme Court reform and then promptly ignored anything they had to say. Where are you on reforms for the court? What do you think is needed? What do you think is wise at this stage? And what would you really try to take off the table at this point?
So, I mean, I think this dovetails with what I was just saying. I mean, I am a big fan of first having the conversation at all. I mean, I think the president's commission on Supreme Court reform really was meant to be a dodge, and so we shouldn't be surprised that it was a dodge. But Congress doesn't have to dodge. Congress can have the conversation. I will say, I think we should distinguish among 3 types of reforms, and hopefully the distinction will help to explain why I support one of them in particular. So there's the sort of the most visible and immediate set of reforms, which is maybe what we might call composition-changing reforms. The push to add 4 seats, right? The push to impose term limits on the justices. Frankly, I think whatever the merits of those proposals, and I'm skeptical of them, there's no political universe in which they're remotely feasible, even with the Democratic trifecta in the next Congress. The sort of the middle category, we might call power limiting reform. So taking jurisdiction away from the Supreme Court over certain kinds of cases, requiring a supermajority vote to strike down federal statutes, right? Reforms of that ilk. I've written about this. I think that for those, it's hard to calibrate those reforms so that they're both effective and constitutional. Right? Jurisdiction stripping, you can do a lot of jurisdiction stripping before you raise constitutional questions. That just won't affect that much. Whereas if you actually say, hey, no more Second Amendment cases, I actually think that would be a big problem. And so this is why I really think the conversation ought to focus on what I call accountability enhancing reforms, which is not taking away the court's power and not changing who's on the court, but Congress reasserting more involvement in what the court does. So a couple of examples, right? Bringing back more mandatory appeals where Congress is telling the justices what to do. We had those. The court only had mandatory appeals till 1891 and still mostly till 1925. We talked about an Article 3 Inspector General. I think that would be accountability enhancing. Congress could codify without changing a bunch of standards that the court purports to apply already in cases in which I think lately it has not been faithful to them, right? And all of these would have as their goal nudging the court to behave more responsibly so that, Jen, if it doesn't, maybe then you build the political consensus for the more aggressive reforms. So I would sort of think about this as a multi-tiered approach where we start with what ought to be the lowest hanging fruit and the reforms that are the least of a sort of progressive assault on a conservative court and the most about restoring a healthier institutional dynamic. And if that doesn't work, then we have the hard conversation. And I think part of the problem of the last couple of years is we've been having this conversation backwards.
Fascinating. Steve, I can't thank you enough. This has been really a geek out for me, a lot of fun. And I cannot recommend enough your book, Shadow Docket, which is up for an award. Remind me what the award is. It's a
finalist for the ABA Silver Gavel Award for Media and the Arts for 2024.
And it's a fascinating look at a once obscure topic that you have now made a household phrase, Shadow Docket, and even incurred the wrath of at least one justice, which goes to a certain lack of decorum and what I would say a lack of judicial temperament, but be that as it may. Thank you so much, Steve, for being with us, and we will have you back maybe to praise Justice Barrett in the future for her turn towards institutional integrity. So,
boy, I hope so.
That would be lovely. Thanks so much, Steve.
Thanks, Jen.
Bye-bye.
Appreciate it.
And that was Steve Vladeck. Wow. I must confess, I have never thought about the Supreme Court's relationship with Congress as a key source of the problems we now experience. And I think Steve is right to a large extent. Now, do we have a set of justices who are particularly contemptuous of public opinion, congressional opinion, oversight? Yes. But that's why you need this kind of superstructure around them. If you're going to have justices that are so ideological and so activist in their mission to reshape American law and American society, then you absolutely need methods of oversight and control. And Steve raises an interesting issue, which is we have to look for a center on the court, not by ideology, but by attachment to certain principles of the law, the rule of law. And that doesn't necessarily need to be a single person. When it was Justice O'Connor, we knew it was Justice O'Connor. When it was Justice Kennedy, we knew it was Justice Kennedy. And before that, perhaps Justice Powell, who was a swing justice. But now we have to look for the help when we can get it. And that usually will mean the three so-called liberal justices. And I resist using that term because unlike their right-wing counterparts, they do not reach the results that please Democrats. Look at the 14th Amendment case. It also includes Chief Justice Roberts, and then from time to time, it will include Justice Barrett, and from time to time, it will include Brett Kavanaugh. So it's an uneasy time in American politics, and in large part a result of, but also caused by, the Supreme Court. And I think we're going to have to get used to some rocky road ahead of us. Many of us would like to expand the court. They would like to have term limits. I would in particular think term limits would be a huge improvement. But Steve's right. It's going to take a generation or more of this discussion and this debate before the political system is ready to accept that. And I mean Democrats are ready to accept that. So in the meantime, we should keep our eyes peeled for Justice Barrett and Justice Kavanaugh. We'll see how they rule on the remaining cases. And remember, there are cases that don't involve Donald Trump specifically that are before the court, including extremely important cases on administrative law and whether the courts and the Congress, which is immovable, will be able to, in essence, undercut, destroy the administrative state, or whether we're going to preserve some realm of discretion for agencies that tackle very complex scientific and other issues that are really beyond the reach of the court, beyond the reach of even Congress. So keep your eyes open. There's always a gun case around the corner. There's always an abortion case around the corner. And, of course, there's the immunity case. So stay tuned. Keep the faith. You can't vote for the justices, but you can vote for the people who appoint them and confirm them. So remember, both Senate and the presidency matter an awful, awful lot. So if you enjoyed this program and you enjoyed our other programs, please tell your friends. They can follow and subscribe at Spotify, YouTube, or Apple Podcasts. Bye-bye.